Disputes arising out of the compulsory land acquisition process, which caused significant financial loss to the government.
The bill before Parliament seeks to empower government to acquire any piece of land for development purposes. It's hoped that this will resolve the current problems of delayed implementation of government projects.
That Parliament should then make a law that will spell out the period within which that dispute must be resolved.
However, the proposal could have rubbed the public the wrong way, with fears now of sacrificing individual rights and powers of courts of law.
Which means Uganda has reached a time where we are passing a law to overturn a decision of court.
We are, on the contrary, streamlining how people enjoy their rights.
In a few cases where government projects have stalled, are some exceptional individuals who rejected compensation as per the value determined by the chief government valuers.
I think this is the weakness of the executive in terms of implementing administrative decisions. It's not a constitutional matter. This is something that you can cure by simply making the judiciary effective.
In this case, it's alleged that many individuals have used government surveys to acquire land cheaply in Project Gazette areas and then later demand for high compensation. Dennis Bugaya attributes this to weakness in some government institutions.
The weakness is somebody in government is properly leaking government secrets to these people. So the solution to an executive weakness within government, should it be passing a constitutional amendment? Of course, no.
To him, amending the constitution is like sacrificing rights of the majority over minority, since it seeks to address issues of a few. He, however, recommends that putting in place principles to support the available laws would be the best solution, rather than amend Article 26.
Principled engagement should precede anything, including the tabling, because you could see they were rushing to table, yet we can refine this thing.
Some of the projects that have stalled due to rejection of compensation by landlords include Kabarole Kamwenge Road, that stalled for over 5 years. Here it is said a one Sangwa resisted government offer of 80 million shillings for a whole 1.2 billion just to allow the road pass through his plot. This compelled Uganda National Roads Authority to divert the road to a swamp.
There's been disagreements with valuations as given by the chief government valuer, or we have found the valuations to be too high for UNRA and government to afford.
Even when the amendment allows one to seek litigation in courts of law, a more worrying situation here is that courts of law are going to be overwhelmed with land cases. It's worth noting that the 1894 Land Law, 1900 Buganda Agreement, 1965 Land Acquisition Act, and the 1996 Land Act all provide for fair and adequate compensation of the land owner. This is supposedly done prior to taking off possession of any property by the state.
If a person objects to the quantum, then before government takes possession, the amount assessed is deposited in court.
To some, amending Article 26 of the Constitution questions the integrity of government to the landowner. They recommend addressing the current issues relating to the acquisition through existing laws or through developing principles rather than amend the Constitution.
Do you think the Act has gaps that you are trying to cure? And if yes, if the gaps are there, do you cure them by amending the Constitution or amending the Act?
This comes at a time when the Ministry of Lands just passed policies which will put to an end any transaction in corridors that have been defined by government as gazettes. These include forests, land in oil regions, road reserves, and swamps. Some of the countries that have implemented compulsory land acquisition in Africa include Ghana and Zimbabwe. Susan Naonga reporting.
as assessed by the assessor.